Well, just now we mentioned the service of the notices to the subject specified persons. One can be served by hand or by sending the copy by post addressed to the last known place of business or residence of the specified person. So there are a total of three methods. One, by delivering the copy personally to the specified person. B, by leaving the copy at the last known place of business or residence of the specified person. Or C, by sending the copy by post addressed to the last known place of business or residence of the specified person. If the specified person of the subject premises is a registered non-Hong Kong company as defined by Section 2, Brackets 1 of the Companies Ordinance Cap 622, a copy of a closure notice may also be served on the specified person by serving the copy in the manner described in Section 803 of that ordinance as if it were a process or a notice required to be served on a registered non-Hong Kong company under that ordinance. I'll move on to talk about brackets 3 and 4. If the specified person of the subject premises is a company as defined by Section 2, Brackets 1 of the Companies Ordinance Cap 622, a copy of a closure notice may also be served on the specified person via the following means. A. By leaving the copy at the register office of the specified person, or B. By sending the copy by post addressed to the registered office of the specified person. In brackets 4, a copy of the closure notice served under subsection brackets 1, 2, or 3 is, in the absence of evidence to the contrary, to be regarded as having been so served on the specified person. A. If a copy is delivered personally on the day on which the copy is so delivered. B. If the copy is left at a place on the day on which the copy is left at the place. C. If the copy is sent by post on the second working day after the day on which the copy is posted, and that is C. In brackets 5, it explains the definition of working day. It does not include A. a public holiday, or B. a gale warning day or black rainstorm warning day, as defined by Section 71, Brackets 2 of the Interpretation and General Clauses Ordinance Cap 1. These are about the service of the closure notices. Mr. Kong has pressed a button. Mr. Kong, thank you, Chairman. Under Section 30E, Brackets 2, if the specified person of the subject premises is a registered non-Hong Kong company as defined by the Companies Ordinance, which I understand, but it doesn't refer to overseas company that is not registered in Hong Kong. Is it specified in law as to the service of such notices? Not all overseas companies are registered in Hong Kong. In brackets 4, just now you mentioned very clearly under what circumstances a copy of the closure notice is regarded as having been served. Does 4C apply to overseas company as well? That is the second working day after the day on which the copy is posted to the overseas company. You set out Section 803 of that ordinance under Section 30E brackets 2. What does that mean? Well, I don't have Section 803 with me right now. In accordance with the Companies Ordinance Cap 622, there is a detailed on the service of notices in relation to non-Hong Kong registered companies. Well, I have it now. In Section 803, one can deliver the notice to the sent to the authorized representative of the company whose required details are shown in the company's register. Or in case the relevant information is shown on the company's register, or every one of the company's authorized representative refuses to accept service on behalf of the company, or the process or notice cannot be served on any of them, there are other provisions. That is, any process or notice required to be served on the registered non-Hong Kong company is sufficiently served if it is left at or sent by post to any place of business established by the company in Hong Kong, or in the case of a registered non-Hong Kong company that no longer has a place of business in Hong Kong, any process or notice required to be served on the company is sufficiently served if 1. It is sent by registered post to the company's registered office or the equivalent in the company's office of incorporation at the address as shown in the company's register. And 2. A copy of it is sent by registered post to the company's principal place of business, if any, in the company's place of incorporation at the address as shown in the company's register. Where no such addresses are shown in the company's register, or it is left at or sent by post to any place in Hong Kong at which the company has had a place of business within the previous 12 months.
Thank you, Chairman. So that means you will rely on the arrangements under the company's ordinance, and you assume that it will be local mail is used. Ms. Kong has also raised another question. What if overseas company is involved and you have to mail the CN overseas, so the second day will be taken as the effective date? That's right. Sorry, I don't think my question has been answered. For number 2, subsection 2, it is stated that for the registered non-Hong Kong companies are involved. So my question is actually, what about companies that are not registered in Hong Kong? I'm not trying to be picky, but I'm just worried. If I don't apply for a license for the SP operations, it seems that you have a loophole here. So I will try to have a company registered elsewhere and not in Hong Kong because they are doing unlawful actions. So that means they may be registering the company in Mauritius or other places and they don't register in Hong Kong. So how are you going to serve the notice? Because for subsection 2, it is very narrow. You are just referring to registered non-Hong Kong companies. What happened to those that doesn't register in Hong Kong? Thank you, Chair. I've read out section 803 of CAP 622. For number 5, they talk about non-Hong Kong companies which are not registered in Hong Kong. It does cover the situation as to how the notice can be served to such companies. Maybe I should read out the relevant clauses. Well, I think Ms. Kong has talked about a situation that is not applicable under 803, right? No, I'm telling you that number 5 of 803 covers the situation raised by Ms. Kong. Can you explain on that? So for the notice required to be served on a non-Hong Kong company, other than a registered non-Hong Kong company, what should we do? If it has a business operation in Hong Kong, then we leave the notice there, or we send it by post to the place of business. If the company has established a presence but is no longer having a place of business in Hong Kong, then there are two ways to do it. The first way is to send the document by registered post to the company's registered office in the company's place of incorporation or the equivalent. And a copy of the notice is sent by registered post to the company's principal place of business, if any, in the company's place of incorporation. So if there is a place of major business, we'll send it there. Where the address of such registered office or principal place of business cannot be ascertained, but the company has had a place of business in Hong Kong within the previous 12 months, then the notice will be left at there or sent by post to that place of business in Hong Kong. Thank you. I think this is a common arrangement about the serving of notices, and we follow the similar framework. Then I think if we continue discussion, then it seems to be a bit overboard. Mr. Chen? For subsection 30E, 3AB, you are talking about the companies which are registered, but what about other corporations or societies? They are not covered by the company's ordinance. They are not registered under the company's ordinance. For example, there can be certain registered associations, and they may be the owner of certain premises, and they may be involved in unlicensed SP operations. So how are you going to serve the notice to them? Because the whole thing is hinged on unlicensed operations. So there is a licensee. If there is a license, there is a name, then there is an address that you can find them. But if you're just talking about a premises which is being owned by someone, but the owner empowers someone to conduct unlicensed SP operations there, so you receive a complaint, and then you go to the premises concerned, you try to collect evidence, you establish that it is illegal operations, then you have to issue a closure notice. Then you will not be able to find the person concerned. You can only find the owner of the premises concerned, or maybe the person responsible for the premises. He may be just renting the place. So that's why when we discussed the definition of specified person, we are concerned, because under such a situation, you may not be able to find the name of the specified person and the way of contacting them. I think for the societies, they may be legal, they may be registered under the society's ordinance, or maybe it is just some illegal operation, and you will not be able to identify anyone responsible. You can only find people who are operating there. So what is your thinking about such scenarios? Thank you, Mr. Chen, for your questions. Actually, for the other environmental protection legislation, we come across such enforcement difficulties as well. Again, we have to rely on the evidence collected. If we're talking about societies, we may be able to trace them down. We may see whether these societies have a responsible person or they have set up a company. Earlier on, you have raised a similar question. You asked, there are some people operating the SP operations there, but we do not rule out that we will be able to collect evidence from them to find out who directed them to undertake such SP operations, and then we'll be able to trace the responsible person. We can see that they are having SP operations there. So In other words, it all depends on the evidence that we have collected. So maybe we would just sue the person on the spot, or we may go further and trace down the route to see who's actually the person responsible behind the operations. We understand that members are concerned about the companies, whether they're registered in Hong Kong or not. But here we're just talking about the different way of serving the notice to them. But as regard which party will be prosecuted, we will try to use different means to try to collect evidence to really identify the person or the company responsible. Well, Chairman, I'm just trying to simplify the question. So would you also add the word societies here? Because here you're only covering companies. So you are saying what you would do if the companies are covered by the companies ordinance, but there are other organizations or societies which are not covered by the companies ordinance. So will you spell out how are you going to serve the notice to them? Will you go back and think about it? So that you may have to propose some amendments here. So please try to enhance the provisions here. Well, for the definition of specified person, we refer to the people who are conducting the specified process on the premises. So whether it is a company or whether it is a society, it will be caught by this specified person. It can also be a natural person. Because we refer to the specified person, that means people who are the person who conducts the specified process on the premises. So I think we can rely on that clause to serve the notice to them and also to prosecute them if necessary. Chairman, allow me to supplement. Well, Dr. Zhang has talked about some scenarios, but I think maybe you will also come across the case of fry tipping. If you receive a complaint and you can caught the fry tipper on the spot, are you going to prosecute the driver? Because the driver may be directed to do so. But if you want to prosecute the case, you will trace behind the driver and the vehicle to see who's responsible. That may be the employer of the driver. So you will be adopting a similar approach. Yes, that's correct. Mr. Chen, any further questions? No, thank you. Mr. Rincon? Chairman, I would like to have some clarification. Chairman, you may not understand my question. For 30E subsection 2, we spelled out clearly that for the registered non-Hong Kong companies, we will rely on the company's ordinance on the way to serve the CN. But for the non-Hong Kong companies, if according to Section 622, there are two different types of companies, the registered non-Hong Kong companies. That is only one group. Another type is that they are not registered in Hong Kong. They are just called non-Hong Kong company according to Cap 622. That means they are not registered in Hong Kong. Yes, that's correct. So that means if it is an overseas company, it can be a non-Hong Kong company. It can be a registered non-Hong Kong company. But under this bill, we are actually mentioning just the arrangements regarding registered non-Hong Kong company, and we will follow Section 803 of Cap 622, but we have not touched upon the non-Hong Kong companies which are not registered in Hong Kong. DOJ has said that we can rely on Section 5 of Section 803 of 622. But if we do not have to single out that case, then why do we need to spell out registered non-Hong Kong company here in Section 30E? So I don't think we are comprehensive enough. So what you're saying that we should change the drafting to non-Hong Kong companies, whether they are registered or not registered in Hong Kong. And then you say that for the registered non-Hong Kong company, you follow Cap 622. But I don't want to miss out the other part. That is the arrangement for non-Hong Kong companies which are not registered in Hong Kong. So you are just mentioning part of the situation here. Why don't you include 803 subsection 5 here? So for Section 803 of CAP 622, it is comprehensive and it covers both non-Hong Kong companies registered or not registered in Hong Kong. So the question is, why don't we follow a similar drafting here in this bill and cover the way of serving notice to non-Hong Kong companies which are not registered in Hong Kong? DOJ? Chairman, a quick response. Of course, we can spell it out here, but another way of interpretation is that if we look at this clause, we are talking about a person, and the person also includes companies under Cap 1. So that means we can serve the notice to the last known address of the specified person. The sections that I have read out to you, which is subsection 5 of Section 803 of the CAP 622, we talked about non-Hong Kong companies. We are also talking about the place of the business in Hong Kong. So if we adopt that section here, it is also talking about serving a notice to the place of business in Hong Kong. But I do agree that it is more elaborate in 803 subsection 5. It also talks about the situation where the business operation has been seized. But after all, it is also talking about serving a notice to the place of business. But for the non-Hong Kong companies, it is spelled out clearly in that ordinance because it concerns the company's register. So that's why we have to spell out the situation there. So for the non-Hong Kong companies not registered in Hong Kong, we can also try to find, we can only find their place of business in Hong Kong. Thank you, Chairman. Chairman, I don't agree with that. Sorry, they are not going to change it, but I want to point out that I don't agree with it. I think we're just taking the easy way out. This is not comprehensive, this drafting. So, administration, can you go back and think about the point raised by Ms. Kong?
Thank you. 30F. Period while closure notices are enforced. Brackets 1. A closure notice comes into force on a date specified by the authority in the closure notice under Section 30D, brackets 2, brackets B, brackets Roman numeral 4. In brackets 2, apart from the service of the closure notice, we'll have to post it as well. So the date so specified must not be earlier than whichever is the later of the following dates. A. The date on which a copy of the closure notice is served in accordance with Section 30E. It specifies whichever is the later of the following dates. In Section 30D, brackets 3, brackets B, a closure notice remains in force until it is cancelled under Section 30N. This is the intended meaning of Section 30F. So a closure notice will have to be served or posted before it can be enforced. Administratively, you will have to pay close attention to the dates, but there is no requirement that the service and the posting of the closure notice must be on the same day. Yes, and that is correct. Ms. Doreen Kong, service is very important. It affects the force of the closure notice and it also affects the commencement of the closure notice, so that, therefore, I hope the administration will review Section 30E. Please see if it is comprehensive. Many of these SPs are conducted by companies instead of by individuals, so please review Section 30E. I don't want your closure notices to be doubted. Even if some companies are overseas companies which do not register, which are not registered in Hong Kong, they will still be covered. Is that correct? I'm no legal expert. The English of Song Dat is serve on. It means you simply have to serve the document or the notice to the subject, whether or not someone is willing to open it. Is that correct? Well, usually when we serve the closure notice, we take a picture, whether or not that subject is willing to accept it or not. If the door is closed, we'll post it on the door and then we'll take a picture as record. No question about 30F. Let's move on to section 30G. During the period while a closure notice issued in respect of any subject premises is in force, the authority may lock or seal or cause to be locked or sealed the subject premises, and disconnect or cause to be disconnected all gas, water, and electricity supplies to the subject premises. Any question? Mr. Ring Kong. Thank you, Chairman. Legal advisor asked a very good question. Can you tell us why Section 30G does not specify the power of entry on the part of the authority? You went straight to locking or you went straight to the point of locking or sealing the subject premises without the power to enter the premises is tantamount to trespassing. You need the power to enter the premises before you can lock or seal it. Regarding Section B, there is substantial power to disconnect all gas, water, and electricity supplies to the subject premises. The premises are concerned are indeed large premises. The closure notice may be applied to only part of the premises. In brackets B under clause 30G, you did not specify the gas, water, and electricity of the part in relation to the conduct of SPs. I think you should make it clear. You only disconnect gas, water, and electricity supplies in order to stop the conduct of the relevant SPs. You don't have to go to the court, so you can simply cut all the gas, water, and electricity supplies to the subject premises. First of all, we'll lock or seal the subject premises. We set out the authority may. It doesn't mean the authority will or must lock or seal and disconnect all gas, water, and electricity supplies. At the first meeting of the Bills Committee, the Director made it clear we do not aim to lock or seal or disconnect all gas, water, and electricity supplies to the entire premises. We only disconnect all gas, water, and electricity supplies to the part concerned. That is, for example, in relation to cement works, we only disconnect all gas, water, and electricity supplies in relation to the conduct of cement works, instead of disconnecting all the supplies to the entire premises. What about the power of entry? Can you tell us more? Member is correct. They are two different things. In our response to the legal advisor of the Council, we also mentioned this. Under Cap 1, Interpretation and General Clauses Ordinance, Section 41, the authority is conferred with such powers as are reasonably necessary to enable the authority to those acts which the authority is empowered to do under the proposed new Section 30G. At the same time, under Section 30J and I, we are given the power to enter the premises. In 30J, the authority may permit people to enter or remain on the subject premises. We'll come to that later. Mr. Chen Xiu-hong. Thank you, Chairman. First of all, I have to declare once again that I'm a senior advisor of a power company, as the discussion has to do with power supply, water supply, and so on. Sections 30GIJ, do they give the authority sufficient power? Just now, Dr. Zheng explained that we'll have to refer to Section 41 of the Interpretation and General Clauses Ordinance, Cap 1. Otherwise, it will become a toothless tiger. In relation to operation, Section 30G mentioned the authority may disconnect all gas, water, and electricity supplies to the subject premises. The subject premises may be very large, and there may be several processes being conducted at the same time. Some processes may be legal, but alongside these processes, some may be illegal. So sometimes disconnection of gas, water, and electricity supplies may not be clear. Power company, water services department may have to enter the premises. They cannot operate private machinery. So sometimes power companies and water companies may be requested to cut the supply at source, and that will lead to another problem. The operation within the same company could not proceed. The purpose of this section is to make sure that non-compliant SPs could not be performed while the subject premises are being locked or sealed, but actual operation may be difficult. Gas, power, water networks may cover not just the subject premises. They may cover premises next to the subject premises as well. We won't disconnect the supply of all public utilities. Say cement works, without power, cement works cannot be performed. You need water to start cement works. Gas may be less important in this case, so we do not have to cut all three utilities before we can stop the relevant works. If we cut power, we won't affect other processes. We will see how to cause minimal impact on the subject premises. The intention is to give the authority a power to enter the premises. Afterwards, the authority may have to do different things to, say, lock or seal the premises. In some cases, the subject premises only have one door. There may be a spot with cement works. They cause pollution. How do you lock or seal a subject premises if the subject premises are being shared with others? You don't have to carve in stone like this. Implementing locking or sealing of the subject premises. Well, I saw that the word used is the authority may. If it can be done, of course, you can lock it or seal it. But when it is not possible, you have to make adjustments depending on the actual situation.
That's correct. Actually, there are two options. In English, we use the word the authority may. So that means we can do either subsection A or B. Mr. Chen has pointed out that there may be a common entrance, then there may be also a common corridor. So are we going to seal just the entrance to the subject premises, or are we going to seal the whole place? We will look at the actual situation. We will only seal up the area where the machinery pertinent for the specified process operations will be sealed. So there are many different scenarios, and we will try to look at the actual situation, but we need the bill to give us the power to close the relevant premises. So the details as to whether we will just close some of the machinery or the whole premises will depend on look at the actual situation. I do understand that. I just want to supplement. I can imagine a scenario, just like Ms. Kong's concern. You are talking about the provision of water, gas, and electricity. There may be a main pipe for such public utilities, and it is difficult for you to close it because it may affect the other unrelated premises, and you shouldn't be doing that. But if a certain installation of plant reaches the notice, then you can go into the premises first and then only sealed up the valve concerning the relevant machinery and installations. But the critical point is whether they will cooperate. If they don't operate, I think there isn't much that you can do. I think you may be facing such enforcement difficulties in future. Thank you. Noted. I think the main objective is to cease the unlicensed operations immediately. So if you can do so by putting a lock, then you don't have to take other actions. But you're just stating here that you may have to achieve the objective of ceasing the operation in order to take certain actions. For example, you may say that generally you may use subsection A, and then if necessary, you would go for subsection B or other actions. I think we have to look at the policy objective. We want to give you the ambit for taking enforcement actions. So do you think you have to amend the wordings here and add the principle for doing so? Chairman, to supplement 2 points. First, when we talk about this power, it only comes after the CN has come into force. So the purpose of issuing the CN is that there is an unlicensed SP operation going on. If the authority believes so, then the objective is clear. We want to cease such operation because a closure notice has been issued, and then there are certain action the authority can take, which is subsection A or B, where some members have pointed out that the actual situation of the subject premises may differ. There may be different users using the premises commonly. So if you want to disconnect the gas or water or electricity, you have to ensure that the purpose of such public utilities is used for that purpose. Then it will be difficult for us to identify such. I have another question. On the content of the closure notice, will you spell out clearly that you will take action according to subsection A and B? Or you're just stating here in the legislation? For subsection A and subsection B, these are enforcement actions. But you are saying that it is during the period while a closure notice is in force. What does that mean? Because I received the notice on the 1st of January, but you are not going to exercise the power on the 1st of January. You're going to do so only at a time you consider appropriate. Is that the case? Well, during the period while a closure notice is in force means that the notice will remain in force unless under 2 situations. First, the recipient of the notice try to apply for a cancellation of the notice. The second scenario is EPD takes the initiative to cancel the notice. So that is what we meant by the notice is in force. So that means you do have the power of not taking action even after the CN has been issued, say on the 1st of January. Is that correct? Yes. But during this period, we can take these actions as stated in the subsections A and B, and to ensure that they are effective. 30H, let's move on. (30H) is about the prohibition on conducting SP process on the subject premises, and there are some penalties. 30H subsection 1 says that during the period when a closure notice issued in respect of any subject premises is in force, the specified person of the subject premises must ensure that no specified process described in the closure notice is conducted on the subject premises. Subsection 2, a person who contravenes subsection 1 commits an offense and is liable on conviction on indictment to a fine of $1 million and to imprisonment for 12 months, or on summary conviction to a fine at level 6, which is $100,000, and imprisonment of 6 months. And in the case of a continuing offense, to a further fine of $50,000 for each day during which the offense continues. Subsection 3, these are defenses. It is stated that it is a defense for a person charged with an offense under subsection 2 to establish that A, the conduct of the specified process in question on the subject premises was under circumstances beyond the control of the specified person. And subsection B, the specified person had taken all reasonable precautions and had exercised due diligence to ensure that no such specified process was conducted on the subject premises. For 30H bracket 4, it is related to subsection 3. We are trying to spell the burden of proof here. It is stated that the person is taken to have established a matter that needs to be established for the defense under subsection 3 if there is sufficient evidence to raise an issue with respect to the matter, and the contrary is not proved by the prosecution beyond reasonable doubt. So we want to say here that the defense in subsection 3 has to be taken by the prosecution. So the prosecution side has to point out all the evidences and the issues of concern. This is similar to other pieces of legislation. So the similar way is being used to describe the burden of proof. Mr. Tony Jie. Thank you, Chairman. Here, we are talking about the specified person and his responsibilities, and also the penalties are actually quite draconian. If on indictment, there will be a fine of $1 million and an imprisonment for 12 months. We are talking about the specified process here. I remember when we discussed Clause 30D, there is a specified form. And there is also need to be a description of the specified process to which the offense relates. So there may be some changes here because you try to describe the specified process and the operator will say, I'm not exactly doing that process, it's a different process. Because we want the legislation to be effective and we don't want to have disputes. In the past, there have been cases that the operators would try to argue for their case. So for the specified process, it is not being conducted in the subject premises. So is it too general to use specified process here? Second, for the defense, it is stated that all reasonable precautionary measures have been taken and they have exercised due diligence. These are the possible defenses. I think it will be up to the court to judge whether all reasonable precautions have been taken and due diligence has been exercised. So you want to provide a defense for the person charged here, but what are your considerations? Can you quote us some examples? What is meant by the person has exercised due diligence? Because the person may say that it is not possible for them to take certain actions. So how are you going to judge that due diligence has actually been exercised? Can you elaborate on that? Thank you, Mr. Chen. On the description of the specified process, we actually have 31 types of SPs. We are now talking about cement works, so we will state clearly that the cement batching plant is undertaking cement works as a specified process. Later on in the amendment bill, we also have a definition for that, so it is very clear. There should not be any misconceptions. Your second question is how to judge that due diligence has been exercised. I think this is similar to the common law due diligence defense. We just try to codify it here. So you ask how are we going to judge? I think we have to look at the situation case by case. For other environmental protection legislation, the defendant will also put up a case. For example, they may say that they have put in place a system and I have also trained my staff as to what they should not do under certain situations. So it will be up to the judge to decide, having heard about the defendant's explanation, whether the defendant has really taken all reasonable precautions. So the judge will also look at the evidence in the case put up by the prosecution side and also the defendant's explanations and to see if it is reasonable. In the past, we have also come across similar situations. So we will try to provide evidence to prove that reasonable precautions have not been taken, but then the defendant will also put up the case that they have taken reasonable precaution. It will be up to the judge to decide which side to believe. Any further follow-ups? No? Thank you. Ms. Doreen Kong? Chairman, a question on principle. For 30H, you are saying that if they carry on the specified process, there will be a heavy fine and penalty. But 30H is actually used in conjunction with the closure notice. For the closure notice, you have the power to lock and seal the subject premises, and you also have the power to disconnect gas, water, and electricity. Also, you would not allow anyone to enter the premises. So, how can the person concerned still undertake a specified process? Because there is nothing provided, no electricity, no gas, what can they do? Well, later on, you can see that for the subsequent provisions, it is stated that they can also remain in the premises even though the specified process is not conducted. That means they can break the lock and seal. They will even enter the premises despite there is a heavy fine. They can choose to do so. So in future, you can see in the subsequent section, you can see that if they try to tamper with the lock, we will have another fine. Thank you.
No more questions. I'd like to ask an operational question. As I mentioned on the service of notices, after you have posted the notices, do you have to lock or seal the premises right away? No, there's no requirement. Let's assume someone knows that a notice has been served, but when you do not lock or seal the subject premises and when the offender is still performing unlicensed SPs within the premises, under these circumstances, is the person still violating the law? Put it this way, after the service of the notices, whichever is later, we'll lock or seal the subject premises as soon as possible. We won't wait, say, a week before we lock or seal the subject premises. We have a plan to liaise with the power companies or water companies in relation to the disconnection of the supplies after the service of the notices. So we have a plan. So what I mentioned won't happen? No. We'll lock or seal the subject premises as soon as possible because we want the offender to suspend the unlicensed SP right away. All these form a package of measures, but you don't necessarily have to do all of them, right? Well, I think we need to be reasonable. On the date on which we go to lock or seal the premises, people on the premises should leave as soon as possible. We won't simply go to lock or seal the subject premises and then prosecute the persons on the premises. Mr. Chen Xiu-hong, I'd like to follow up on the legal advisor's question. For the new offense, is it strict liability offense? Yes, according to the administration. The legal advisor cited a few cases. This is a strict liability offense, so it is sufficiently clear that as long as the defender has a defense under common law, then the prosecution would have to prove the contrary beyond reasonable doubt. Is that correct? Strict liability offense means that no mens rea is required. In relation to the burden of proof, it has nothing to do with the strict liability. It is the defendant to raise evidence in order to prove or disprove his or her own guilt. Now it is the prosecution that is to prove the defense raised by the defense is not valid. Legal advisor. Thank you, Chairman. We've asked the administration whether the offenses are strict liability offenses. The administration's reply is in the affirmative. In relation to defense, in accordance with 30H, bracket 3, it is a defense under the ordinance. 30H, bracket 4, it sets out clearly who has the evidential burden. If one invokes section 3, bracket 3 under section 30H, one shoulders the evidential burden. Then the prosecution needs to prove the contrary. In our letter, we also asked for common law for strict liability offenses. There is the common law defense of honest and reasonable mistaken belief. So is the common law defense ruled out? In section 30H or other provisions, the administration does not have any intention to rule out the common law defense. There is no legislative intent to raise the evidential burden either. The prosecution is required to prove the contrary beyond reasonable doubt. We are referring to two different types of defense, but the evidential burden is the same. In Section 30G, authorities' power to close subject premises. Locking is the easiest way. It is also significant. It means you are not allowing other persons to enter the subject premises. One cannot continue to perform SPs. If the administration wants to do so as soon as possible and bans other persons from entering the premises or continuing with SPs, would you consider adding the words acting as fast as practicable? Would you make clear your action because after locking the premises, you are not allowing other persons to carry out SPs, otherwise one is liable to imprisonment. Thank you, Chairman, for your questions. I'll see if the DOJ has anything else to add. In any event, we'll act as fast as possible. Once we have the power, we want to protect the environment as well as the health of residents living nearby, so we'll lock or seal the subject premises as soon as possible. Chairman asked whether we would add the words such as doing so as soon as possible, as fast as practicable. I'll see what the DOJ thinks. Thank you, Chairman. Whether we need to add these words or not, we need to consider administrative flexibility. When we set out these, the administration has the responsibility to exercise due diligence and lock the subject premises as soon as possible. Without these words, however, the administration can consider the individual situation of different cases and make arrangements accordingly. So it's all about the directions of the policy. If we want to make it applicable to all scenarios, all cases without any flexibility, then we can consider adding these words. Otherwise, the current provisions retain administrative flexibility. If the administration wants to act as fast as practicable, then adding these words may be better. I don't want to leave any room for argument. Somehow, for some reason, someone cannot see the notice or the notice is blown off by wind, or when the notice is served on the workers unbeknown to the employer or the person in charge, then someone would have an excuse. We don't want to leave any void for arguments. After all, if the administration is not locking the subject premises on the same day and when the offender is being prosecuted unbeknown to the situation, when we serve the notice, the other party definitely knows it. As Mr. Choi mentioned, this only applies to unlicensed SPs. When the offender is not willing to comply with our orders, then the administration has no choice but to serve the closure notices. We'll see how to add the words like as fast as practicable or due diligence. Mr. Chen Xiu-hong, writing on your point. I'd like to ask why the word may is used to give the authority flexibility. As we discussed, in some situations, the authority could not lock or disconnect all gas, water, or electricity supplies in a short period of time. When you add the words as fast as practicable, then you have a definition of this word or of this term. The key is upon the receipt of the closure notices, when one continues to carry on with the SPs, then one violates the law. We aim to give the authority the power to decide when to enter the subject premises, or when one when the authority locks the subject premises. There are both pros and cons. Someone may use the excuse of not receiving the closure notices. This gives an opportunity for the offender to lodge an appeal. But from day one of the receipt of the closure notices, actually someone is already breaking the law. If someone has reasonable excuse, say a third party damages the notice or even removes the notice, then it is another story. Someone doesn't just knock on the door and lock the premises. There must have been prior conversations. Chairman has made a very good point. The administration can discuss with the DOJ to see if there is any room for enhancement, whether we should add these words. Thank you.
你寫唔寫都好，即係
Mr. Chen, thanks for your points. Anyway, we will include such wordings in the enforcement guidelines so that our colleagues will understand that we will do so as soon as practicable. Chairman, for the enforcement guideline is internal guideline, right? Yes, that's correct. It is not open to the public. We will not issue that to the public because we have an enforcement manual for the different legislation so as to alert our colleague as to what they should do and at what time. So these are internal documents. Chairman, I can understand that those are administrative documents and administrative arrangements and they need not be published. But when we discuss further after scrutiny of this bill, the government will have to publicize it and then conduct public education. We may touch on certain scenarios and you would have to think about how you should explain the case to the trade and the public. Thank you. I think the administration should go back and see how they can communicate better with the trade. We now move on to Clause 30I. Well, some members have raised questions earlier. What happens if there are people entering and remaining on the subject premises? This will involve a penalty. Section 30I, bracket 1, subject to subsection 3 and subsection 30J. During the period while a closure notice issued in respect of subject premises is in force, a person must not enter or remain on such premises. A person who contravenes that will be committing an offense and they will be liable to a fine of $200,000 and an imprisonment for 6 months. And in the case of a continuing offense, to a further fine of $20,000 for each day during which the offense continues. 30I, bracket 3, subsection I does not apply to a public officer who enters or remains on the subject premises in good faith in the course of the public officer's duty. So this is what Section 30I covers. Any questions? Mr. Chen Xiu-hong? Chairman, I think the intention of 30I is clear because the place is closed, so no one should enter except public officers for exercising duties. So in the case of emergency, even if the place is locked, for example, if there's a fire or if there are other emergent situations, it seems that 30I won't allow people to go in. We actually have a provision for covering the emergent situations. There will be subsequent clauses covering other people who go into the premises under emergent situation. Ms. Doreen Kong. Well, Chairman, I'm not so much concerned about emergent situation. I'm concerned about security and management issues. For such huge premises, if they do not undertake a specified process, why isn't it possible for a watchman to stay at the premises? Because this is a facility. I don't think you have such power to do so because the land may belong to the operator. They are just not doing the unlicensed operations, but you are very draconian power here. You are not allowing anyone to enter. For example, they may be able to sell the premises. So I may want to put someone there to manage the facilities or to work as a watchman. Why don't you allow for such scenarios? Thank you, Ms. Kong. When we move on to Section 30J, that will be able to answer your question. We are not allowing anyone to go in. So if there is safety reasons or there are security reasons or some special circumstances that require someone to go into the premises, we would allow so. Or maybe they don't want to carry on the SP process illegally, they want to move away the equipment concerned, we would allow them to do so. So we allow for the person to apply to us for entry into the premises. Maybe I would talk about Section 30J now, Chairman. Well, Chairman, I understand that, but I want to speak first on 30I, Section 30I. I have actually looked at Section 30J. What I have in mind is that a person wants to enter his own premises. It's different from not allowing them to undertake unlawful processes. So there are two issues. You are depriving a person of a right to enter into his or her own premises. Why do they have to ask for permission from the authority to do so? I think this is disproportionate. I'm entering my own premises, but I have to seek permission from you. Don't forget that we are now talking about a situation whereby the specified process can cover 31's operations. So why do we need to require the specified person to apply for authority to enter his own premises? Why do you have such great power? Thank you for the question. Well, we understand that there is freedom for everyone, but if we look at the case holistically, this premises has been undergoing specified process operations which are causing nuisance to the residents nearby. So of course, there is the freedom to enter the premise, but we have to strike a balance. I do not rule out that they want to enter into the premise for emergent work. They may want to say that they are willing to pay the fine and still they want to carry on the SP operations. So we're trying to strike a balance here. We're saying that you can enter the premises, but you have to apply to the authority first. If there is a case that merits such entrance, say for service maintenance or for security purpose, we would allow them to do so. So I hope, Ms. Kong, you will understand the situation. Well, colleagues, I think let's try to scrutinize 30I and 30J in conjunction. Chairman, for Section 30J, it gives the permission for a person to apply to the authority to remain or enter into any subject premises that has been locked or sealed. 30J Section 1 is that the authority may, in writing, permit any person to enter or remain on any subject premises. 30J bracket 2, in granting a permission under subsection 1, the authority must specify in the permission the purpose for which the person is permitted to enter or remain on the subject premises. And B, may impose any condition that the authority considers appropriate on the permission. For example, we specify the time that they are allowed to remain on the subject premises rather than a blanket permission, or we would say that during this month we understand that you have to undertake some process and you will not cause nuisance, we will allow them to do so. So these will be the conditions to be imposed by the authority. Subsection 3, the authority may revoke a permission if the authority has reasonable cause to believe that the purpose specified under subsection 2 bracket A in the permission no longer exists. This is subsection A. That means the specified process is not being conducted. Or subsection B, a condition imposed under subsection 2B on the permission has been breached. Well, for example, we allow them to go into the site to conduct maintenance, but then they go in and conduct the operations, then it will be breaching the condition for the permission to enter the premises. So this is what Section 30J covers and allows the authority to permit people to enter or remain on the subject premises. So Section 30I and 30J, let's scrutinize them together. Any question from members? Mr. Rincon. Chairman, I have a question. This is a Bills Committee. I understand that it is not possible to write down everything in the legal provisions, but I would like the administration to explain. If under Section 30J you give permission for people to enter the subject premises, under what circumstances or what principle would you use for allowing such permission? Because you haven't spelled out the situations or principles that you use for allowing people to enter. If there is an application put in, what information would you require from the applicant? It is very loose here. So what evidence would you look at and what information would you need and how long would it take for you to grant a permission to enter the premises? Thank you, member. Our main concern is that they go into the premises, they are not going to continue with the SP operation. We do not allow them to continue to use the machinery for the SP operations. If there may be other installations within the machinery and they may have to remove and change part of them, for example, like the air sealing. Otherwise, there may be danger. Then there may be a fire as a result or even an explosion. So these are safety reasons. And generally, we will allow them to go in and conduct service maintenance so as to ensure that the machinery, even though it is not in operation, they will not cause any accidents or damages. The second question is how long would it take? It will be similar to the situation whereby we give a permit. If they can provide the pertinent reasons and relevant evidence as to why they need to enter the premises, then it will take longer. But otherwise, we will be able to give a permission quite quickly. A follow-up, Chairman. Security. Is security a reason for granting permission to enter the subject premises? Second, if during the closure of the premises, you would not allow anyone to go in and you will disconnect water and electricity and gas, if there is an accident on the subject premises, who will be responsible for that? Chairman, I will take the second question first. If there is an accident, that is why we have to give them permission to enter. If the operator is aware that they have the responsibility to ensure that the installations and the machinery will not cause any problems like fire or explosions, they can come to us and apply for permission to enter the premises to conduct maintenance. We will not stop them. We will grant permission for such reasons. The second point about security. So we need to see what is the purpose of security. If they are just worried that people would go in and damage their machinery, then we will say that the premises has been closed. So that means anyone other than those permitted by us cannot enter the premises. If the operator uses security as a reason, simply just security, then we don't see why we can grant permission. I think they need to give us some further reasons as to why it is a must for them to enter the premises. As I have explained earlier, we do not want people to make use of this loophole to enter the premises which has been closed by us. They may have a huge order and they cannot stop the process, so they want to go in and continue with the operation. So that's why we close them. We don't want them to continue the operation, but we have to give them the chance to go into the premises and conduct suitable actions like maintenance. So that's the rationale. Chairman, a supplement. Well, having listened to the administration's reply, I'm a bit concerned. If they conduct SB operation and they breaching the law, you want to close them, I have no problem with that. But if you are saying that you're worried that they will go back inside after getting the permission and they will continue with the operation, then I have some hesitation. Because in Hong Kong, you will only breach the law after you have really actually breached the law. But you are now just suspecting that they may go back and resume operation. So it seems that you are trying to assume that they will carry out unlawful actions. I'm sorry that I cannot agree with that. Because under the common law spirit, you cannot assume everyone should be presumed innocent after they have breached the law. If you say they use security as a reason and you will not allow that because you suspect that they may resume operation, I do not agree with that. But I do not agree that the administration will tackle the issue or look at the issue from that perspective.
個邏輯啫，我想
Ms. Dorin Kong, well, the logic is that when I have locked or sealed the subject premises, then I am not allowing any other person to enter the premises. Otherwise, why would I be locking or sealing the subject premises? If a lot of land is owned by someone, then where does the power come from? The basis of this power is that the offender repeatedly commits the offense, is prosecuted without intending to stop. This is a practice targeting unlicensed SPs. Dr. Franking An. Thank you, Chairman. I have a question. In 30I(3), public officers who can enter the subject premises in case of fire, for instance, fire officers, of course, can enter the subject premises. What if the fire officers require someone to open the log or to help with investigation? Do these persons still have to obtain written permission from the authority in accordance with Section 30J(1)? Thank you, Dr. Franking An, for your question. We'll come to the emergency provisions later on, which will solve the problem you mentioned. I'll talk about that when we come to it. Well, can we talk about it right now? Well, can you answer Dr. Franking An's question now, Dr. Sunny Chang? Yes, there are a few situations in which even if you do not comply with the closure notice, then it is not an offense. One, your life is a threat, or to protect one's safety, say in case of fire, when fire officers need to break in the subject premises in order to rescue someone. Apart from personal safety, when one needs to protect belongings, one can also invoke this ordinance. When a road is blocked, say the prevention of a serious interruption or disruption to any public transport systems or public utilities in an emergency situation. Well, that is not an emergency, however. The administration was referring to 48A brackets 2B, the prevention of damage to any property in an emergency situation. But the situation I mentioned isn't an emergency situation. Well, in your situation, the person can apply in accordance with Section 30J, saying that the fire officer requires me to enter the subject premises. That person will have to receive written permission by the authority before that person can enter the subject premises. You are requiring written permissions. It takes a few hours, the fastest. So my question is, will you consider adding the words for those acting upon the instruction of a public officer, then someone can also enter the subject premises? Well, if fire officers who are public officers as well need to enter the subject premises, well, I mean, that person being requested to enter the subject premises is not a fire officer, is not a public officer. DOJ, in Section 30M, there are defenses for contravention of Sections 30I, K, or L. Using the example given by Dr. Franking An, if someone genuinely believes that someone enters the subject premises only to help put out the fire, then someone has a reasonable and honest excuse. If the FSD requires someone to enter the subject premises, of course, we allow that. I understand that, but the procedure right now is that someone needs to obtain a written permission by the EPD before one can enter the subject premises. So how long would it take? So my question is, will you consider adding under Section 30I bracket 3 as long as someone is acting on the instruction of a public officer, say a fire officer, to enter the subject premises to put out fire, then someone is not in contravention of the ordinance? Dr. Franking An, yes, what you mentioned is in line with the situation or is practicable. Mr. Chan Siu Hong, the emergency I mentioned applies to Section 30I. Section 30I, prohibition on entering or remaining on subject premises. In our discussion, we talked about defenses or exemptions in case of emergencies, and the administration was referring to Section 48A. I'd like to seek clarification from the administration. Defense of emergency is only applicable to Section 10, bracket 7, 12, bracket 2, 13, bracket 2, 28, bracket 3, 38, 69, bracket 9, 73, bracket 2, or 79, bracket 7. Why don't you add 30I as well? In case of emergency, if someone enters the subject premises, if one knows that there's a fire on the premises, one still needs to obtain written permission before one can enter the subject premises. When one still enters the subject premises nonetheless, then someone still breaks the law in contravention of Section 30I. But Section 30I isn't covered under Section 48A. After closure notice is issued, when one enters the subject premises to put out fire, one is not protected under Section 48A. We'd like to clarify. In Section 30M, there's a defense. It is for Section 30I, and this will solve the problem asked by the question asked by Dr. Frank King-an. When we go to Section 30M, you'll know that there's a defense. The way you draft it might lead to misunderstanding of the public. This is a catch-all provision. In other provisions, you mention emergency, but it is not covered by 30I. Instead, it is protected by Section 30M, which is a catch-all provision. Will there be conflicts? Well, they are different. One is an emergency situation, for example, to save people. Even if one doesn't hold license, in case of emergency, we can still grant exemption. Section 30M, the defense, the scope is wider than emergencies. Say if someone enters the premises to aid in the investigation, this is not an emergency situation. It will be covered by Section 30M. Does one need to apply for a permission? In our opinion, it is not necessary, but we can review the situation. Section 30M and Section 48A are different. Section 30M has to do with Section 30J, 30K, and 30I. Rather, Section 30L. You are adding a wider defense to cover, for example, Section 30I. Should Section 48A be made applicable to Section 30I, 30J as well? Are you worried that Section 48A may be at odds with Section 30I? Otherwise, why don't you include Section 48A under Section 30I as well? When someone breaches Section 30J, 30K, 30I, then 30L, then someone can raise a defense in the court. In case of fire, someone wouldn't be willing to take part in the investigation, otherwise he or she may be prosecuted. Well, we'll go back and think about it. Thank you, Chairman. It's impossible to finish clause-by-clause scrutiny today. Section 30M and 30N should be scrutinized together. I'm afraid we don't have sufficient time. So I suggest we wrap up the meeting right now. As the chairperson of the Bills Committee, I hope members will understand that I hope to finish clause-by-clause scrutiny within January. Some panels haven't started policy discussions yet in January. After January, it will be difficult to book conference rooms. So I hope members will understand this. Thank you. Meeting adjourned.